Good afternoon, and thank you for tuning in to the Cordell Cordell webinar, specifically the 10 stupidest mistakes men make when facing divorce. I understand that there are some technical difficulties for some of you trying to access the live stream, so we apologize for that. Hopefully that has been corrected. And again, thank you for taking time out, not only to tune in, but also to register. And we're going to be covering what we call the 10 stupidest mistakes that men make. And you can find it here in our book that is available on Amazon, and you can purchase it. And it goes into much more detail. Today, we're just going to cover the 10 mistakes and the most important facts in each one. But for more information, please check out this book because it does go into much more specific detail on what to avoid and reasonings behind that. I just want to advise everybody that I am not licensed in Kentucky, but I am licensed in Missouri, Illinois, and North Carolina. And so this information that I'm giving you is more of a general idea and to be really more educational for you and to help you be a little bit more prepared when thinking about decisions of divorce or after divorce or interviewing attorneys, questions to ask, what not to ask. And we'll go over a lot of this information in the time that we have together. It's a very short period of time, so we're going to go somewhat quickly through it. But again, I'm going to highlight some of the most important information that I think is important to you. But also, I spoke with some of my colleagues, and I brought some notes with me, and I hope that's okay. But I wanted to make sure that I'm giving you some good information that you can take notes on our experience and my colleagues' experience. And we do seminars across the country. We can go into much more detail, but unfortunately our time is limited. And so we're going to quickly go through it. We are a national firm. We have offices across the country, specifically in Kentucky and Louisville. We have approximately 280 attorneys, and we're a firm that focuses on domestic relations. So issues before divorce, during divorce, after divorce. We handle paternity, divorce modifications, prenuptial agreements, postnuptial agreements, child support, alimony, maintenance, contempt actions, orders of protection. All this information is addressed in our books that, again, you can find on Amazon. But today we're specifically going to be focusing on the 10 stupidest mistakes, or the 10 most common mistakes that men make when facing divorce. And if you find yourself making some of these mistakes, it's not the end. We can give you some tips to try to correct them. So let's dig right into it. And if we have time, there are some common questions that people have asked that I'll try to answer if we have time permitted. If not, if you're tuning in for our Kentucky office in Louisville, I highly encourage you to schedule a consultation. So with that, let's jump right into mistake number one. And I get asked this question all the time, whether it's from potential clients or clients that are coming in for an initial consultation, and that is moving out. Should I move out? Can I move out? When do I move out? I've already moved out. Is that going to be an issue? So let's break it down into two different phases or categories. Moving out potentially when there are no children involved, and moving out when you do have kids. So moving out when there are no children involved could have significant legal ramifications. And this is something that I highly encourage you to talk to your attorney about if you have one. If you don't have one, that's fine. It's something you're wanting to discuss with an attorney. And if you're thinking, well, who do I contact? We're going to go over that in one of the slides as far as one of the mistakes as far as getting the right attorney or speaking with the right attorney, hiring the right attorney. It's a comfort level, and we'll go into that more detail. But moving out could have some legal ramifications, which could be you're setting the tone or the precedence in the case that you're okay with your spouse having that house. If you move out, you're going to potentially have the dual expenses. So not only do we need to make sure that the marital expenses are being paid, but now you have your own expenses. And what can you afford? Could be in a position where your spouse is in the house and having access to all the amenities in there while you're in a smaller place that you may not even own. You may be renting, whether short-term, long-term. Something to think about. If you do the short term, what are the costs associated with that? If you're long term, how long are you locked into that particular rental agreement or lease agreement? And what are the costs to break that if need be? And then you're in a situation where you're focusing on making sure that the marital expenses are being paid for, the utilities, the mortgage, things like that. What can you really afford? So you have that situation there. You have your spouse that's in the house with all the amenities, the bed, the utilities, the refrigerator, everything. And then here you are potentially in a smaller place and lying on a mattress and really don't have much because you're focusing on making sure that the expenses are being paid. Another issue could come into play to where if you move out, you could be saying to the court, I'm okay with my spouse having that house, when in actuality, you really want that real estate or that house. So something that we want to think about if you move out, are you giving your spouse the upper hand in that particular situation? And then, as I mentioned earlier, you have the dual expenses to where you could be setting precedents that the court's going to look at and maybe come to the conclusion that, well, if dad moved out, well, then clearly he's okay with it. And even worse, the court could say, well, you can clearly afford to pay for expenses. So you have the dual expenses that the court could say, if dad can afford this, well, we're just going to continue that. And that really goes back to that precedence or stability that I mentioned earlier. And in my practice and speaking with my fellow colleagues, courts do put a lot of focus, a lot of attention on that precedence and what is the current situation. The majority of the time, this is something we'll discuss later on as far as when to file, but when you file or when you move out, you're kind of taking a snapshot of what the current situation is. So if you're moving out, you're given that impression that this is okay, I'm all right with this, and I can afford both. And that may not be the situation. So we really want to make sure that if you move out, then we want to be strategic about it. Of course, if you fear for your life or safety, I'm not advising you to stay in the house. Then we need to take substantial steps and measures to make sure that you're protected. The other part of this, as far as moving out, and this is why I have it as number one, because it really is one of the most common questions, if there's children involved. And that could be very problematic if you move out and the children or the child is there with the other spouse. And the reason why that could be so problematic is because even though you still are involved with your kids and you love your kids and you want to be there for them, if you move out, what your spouse is going to say to the court is, dad moved out. He doesn't really care about us. He decided to move into this apartment, this house, and he's more focused on that particular situation than being here with us. But even more importantly, and more caution that I urge is, before moving out with children involved, we want to make sure that there's some type of visitation in place, some type of temporary custody in place. And these are questions you're going to want to discuss with your attorney to make sure that you're positioning yourself in the best possible position, putting your best foot forward, essentially. And if you move out, what usually happens that we see when clients come in to meet with us is they've already moved out. It's been either a substantial period of time or even, quite honestly, a week or two, and they either haven't seen their kids or they've only seen them for restricted periods of time. And why that's important and why there's a lot of caution to that is because, again, you're setting that precedence, that stability to where dad's out, dad's okay with not seeing his kids, which clearly for most individuals, most dads, that's unacceptable, or dad's okay with the restricted time. Again, for most dads, that's unacceptable. But without any of those temporary court orders in place or measures in place for you to see your children, then you're essentially telling or advising the court, I'm okay with this situation. And you can bet that mom's going to go into court and say, dad moved out on this date. He's only seen the kids this amount of time, if at all. He's only made communication or contact with them this amount of time or at all. So here's what I'm asking for. This is why. And even more importantly, Judge, we need to keep the current situation, which is dad's out of the house, dad has restricted time with the kids. Let's implement this into a final order. And that's going to have a lot of ramifications. Most important being the amount of time and the quality of time that you see your kids, but there could be financial situations and financial consequences dealing with child support that you're going to want to take into consideration, and have those discussions with your attorney, or if you don't have an attorney, when you have an initial consultation, you're definitely going to make sure that you address that. So before moving out, I highly encourage you to speak with your attorney or consult with an attorney before you do that. One thing that I wrote down here, and just think about this question, because we ask this in seminars all the time, and we do it by a show of hands, but clearly we're not going to do that here. So, but just think, are you familiar with PAS, which is Parental Alienation Syndrome? Now let that sink in just for a second. Parental Alienation Syndrome. It's similar to what you're probably thinking, to where, okay, I'm not really getting time with my kids, or maybe my kids are being fed some wrong information, and you're not that far off. A really good example is, you're out of the house, you have kids, mom's there. The mom said, I don't know where dad's at. He hasn't called. He must not want to talk to you. He must not want to see you. Or, dad moved in with his significant other, and he's more interested in that person than you. Or, oh, I'm sorry, we can't do that tonight because I don't have any money because your dad decided to move out. You may have heard of this. You may even be involved in a situation like this. It's unacceptable. And it's something that we're seeing courts recognizing more and more. And it really affects not just the custody agreement or the way that we want to present a case, but it affects your time with your kids and how your kids view you. And we know that we don't have that long with our kids, because they grow up so fast, and we want to just take advantage of the time that we can have and we do have with them. And so we really want to make sure that we're focused on the best interest of the kids. So think about that particular situation if you have these thoughts that you want to move out. If you can, go downstairs if you are able to, or go into a separate bedroom. I know I'm speaking with one of our partners, and he always gives the example that he had a client that they would have literally a security system in their house on different levels. Now, that doesn't work for everybody, and everybody can afford that. But the point is, they put parameters in place to where they try to make it work for the best interest of their kids. So maybe that's something you can consider. And if you're in a separate room, put a lock on the door that only maybe you have the key to, so at least you have some sense of privacy in an area that you can retreat to. But the main focus is, if you do not have to move out because you don't fear for your life or safety, try to avoid it before talking to an attorney, because once you move out, then it really puts you and your attorney at a great disadvantage. We're behind the 8 ball. And so we want to be a little bit more proactive. So I know I focused probably a little bit more time than I wanted to on this first mistake, but at the same time, it is probably the biggest mistake that people make, and it is the most common question and concern and issues that we deal with when we're meeting with potential clients. So we'll move on to the next mistake here, which is mistake number 2. I mentioned earlier, choosing the wrong lawyer. This could have drastic effects. So you really want to make sure that you're meeting with someone that not only do you feel comfortable with, but that has the knowledge, the experience. And in today's day and age with the internet, there's a lot of homework that you can do on your own to research not just the qualifications of this attorney or the firm, but really, what do they focus on? When you're dealing with domestic relations, family law, you want to hire an attorney that's where their primary focus is. If not, really, that's all that they practice, because the family law is an ever-evolving, changing practice, and there's so many nuances in statutes and laws and case law that if you don't practice it on a day-to-day basis, then you're really representing your client in not a positive way, and really putting them at a severe disadvantage. And so we want to make sure that when you meet with that person, that they have that knowledge, they have that skill set. Ask them the questions as far as, what are your thoughts on settling? What are your thoughts on trial? I can't tell you, a lot of times when I would have cases and be preparing for trial, that the other side, as soon as we get ready for trial, we're on the eve of trial, they're pushing settlement. And it's not in the best interest of their client, because they don't want to go to trial. And to me, it just never made any sense. a surgeon telling their patient, oh, well, we'll just push off the surgery. Well, why would you do? You wouldn't do that to your patient. And why would you go into surgery if you don't want to perform surgery? So if you're a client, you're going to want to make sure that you're speaking with someone and hiring someone that practices and focuses really in the domestic relations area. And ask them, what is your communication like with your clients? I can tell you here at Cordell, we have a communication policy to where if you're a client and you call or you email on a business day before 5 p.m., somebody will get back to you. That floors a lot of people, because I can't tell how many times people come in and meet with me and they say, I have no idea what's going on in my case. You won't get that here. We can never give you a guarantee, but I can guarantee you that you would get good customer service here. We can't guarantee the results, but at the end of the day, you need to know what's going on in your case. And I can tell you for a fact that your case doesn't go 9 to 5. Things happen in the evening, late at night, early in the morning, on the weekend. And our attorneys, we're here for you. And we want to make sure that your questions are answered. If any issues come, what can you do? Because you don't want to put yourself in a precarious situation that could have drastic effects on your case. You may not be thinking of it now because you're more focused on the short term, but we're going to be focused on the long term and know what are your goals. And you want to feel comfortable with that attorney. You want to tell them what are your goals. And you want to let them know that here's what you're focused on, but are there other alternatives? Because there are some times where you could meet with somebody on one particular issue, but really you need to focus on another one. And maybe that would put you in the best position possible. Because at the end of the day, the theme I like to use is we want to put our best foot forward. And as we go through these slides, there are some themes that I'll point out, and I'll give credit to one of my partners who came up with some of these themes, and they've resonated with me, and I like to use them when we do seminars. But the putting your best foot forward, we want to make sure that we're looking at everything in your case. And maybe now isn't the right time to file. We'll go over that a little bit later. Maybe here are some things that you need to start doing to position yourself so when it does come time to file, you're in a much better position than you were when you first came in. So you want to make sure that when you choose that attorney, you want to make sure that you're comfortable with, but also don't cut corners if you're interviewing a couple attorneys and one of them is a lot cheaper or maybe even just a little bit cheaper. This is the time where you really need to put costs aside and focus on what is best for you, what is best for your case, and what is best for your family. So we're going to move on then to the next mistake here, which is mistake number 3, waiting for your wife to file. This is really another common question that I get, that my colleagues get, and it's sometimes it's a hard one to answer because each case really is different, each jurisdiction is different, and there are a lot of procedural advantages and there's a lot of procedural disadvantages as to when you want to file. Overall, we always like to be proactive here at Cordell, and depending upon the jurisdiction we're in, we really want to be the ones to file first. And I say that because once you file, then you're taking that snapshot of what the current situation is that I mentioned earlier, and you'll be the petitioner, so you'll be the first person that the judge reads their pleadings. You'll be the first person that the judge hears. The very first thing that judge is going to read is going to be filed by you. And also you're going to set the tone of the case and a lot of times the time frame of things. In some states, I know in Missouri and Illinois, you can take a change of judge. Each side gets the opportunity to take a change of judge. So it could be procedural advantage that when you file, you know, okay, well, now we know who this judge is. Based upon our experience, we probably want to take a change. So let's at least eliminate a judge based upon your particular issues that really wouldn't be a good fit or advantageous to your cause. Also, depending upon the jurisdiction, and I know in some of the states that I'm licensed in, once you file, then that just draws the line in the sand. Not really the line to your spouse, and of course it does. It puts them on notice that, hey, I'm filed for divorce, but more along the procedural lines dealing with property and debt, because in the states where this comes into play, that date of filing is very important. I know in North Carolina, usually that's considered a date of separation, and you've got to wait a period of a year and a day before the court would grant what we call an absolute divorce, which is just divorcing you, not dealing with any of the property or the debt or the custody or the financial aspects of it. But in in other states, it could be important to where that date of filing, anything that happens after that could absolve you of any liability. So if you file, let's say, for example, today, February 4th, and your spouse on February 5th goes out and accumulates $20,000 worth of credit card debt, you may not even be liable for that. So that could have huge financial ramifications. Or maybe you go out and win the lottery, right? If you go out and buy a lottery, file today, you buy that ticket tomorrow, and you win it, that could be potentially considered your separate property. So there's issues that we need to discuss with you, and that you want to make sure that it's being addressed with your attorney. When is the right time for me to file? Now, that could work against you, because there are some jurisdictions to where maybe it's not advantageous to file because that doesn't put you in the best possible position. So that's definitely a discussion you're going to want to have with your attorney. Is this the right time for me to file? What are the advantages of me filing right now? What are the advantages of me waiting? I know, and I'm sure some of you may have experienced this a few years ago when we were having the stock market decline and the economy really wasn't doing as well as we hoped it would do. And I know one of our partners was interviewed, and they asked him, your clients probably can't afford to get divorced because they don't have the money to do it. And it's really, no, they really cannot afford to not get divorced, because this is the most opportune time. This is when their income is the lowest. So going back to taking that snapshot, it really does. This is what my client is earning right now. And if you're in between jobs or your income's a little bit lower, maybe this is a time to file. Another issue to take into consideration is going to be, how long are you married? Some states have formulas, calculations, guidelines that base financial exposure on the length of the marriage. Maybe there's that magical number to where if you've been married less than this period of time, there is no exposure to that alimony. Or maybe once you've been married a certain period of time, you're paying permanent alimony, or it really increases the likelihood that you're going to be paying something. So you want to take what I'm saying into consideration, just jot it down and put it in an outline when you're going into talking to an attorney, as far as, okay, here are some things I want to make sure that we cover and get answers, because you do not want to put yourself in a situation where you thought you were putting your best foot forward and now you're in a situation where maybe you should have waited to file, but instead now the process is going on. So we want to make sure that we deal with the income situations, and we want to make sure they're dealing with the property situations when filing, because there are some strategic things that you probably want to do before you file. The last thing that I want to cover when it deals with waiting for your wife to file, and again, this is going to be state by state, but in North Carolina, where I'm licensed at, affairs matter. And that could be the difference of you not paying any type of alimony, or you paying alimony, or you receiving alimony or not receiving alimony. So we've got to look at it from both situations, depending upon what your current situation is. And so that's something that we want to take into consideration, is what is the conduct that you have, and what is the conduct that your wife has. And lastly, with conduct being said, when we file, as I mentioned earlier, you're the first person to file. You're the first plea, and the judge is going to read. And if there's any issues with alcohol, drugs, abuse, anything like that, let's just get it out in the open. Let us be the ones to bring it to the court's attention, and then we move on. And then, as opposed to the other side saying, aha, we're fine because there's this alcohol, this drug issue. Judge, we really need some help. This is why the marriage is broke down. And really just painting your spouse out to be this victim, when in reality, there is no issue, or you've corrected it, or you're rehabilitated. So there's a lot of things that we really want to think about, discuss, take into consideration before we file. And lastly, there are maybe some procedural advantage for your wife to file first, and that's something that you're going to have those discussions with your attorney. So we'll move on to our next mistake here, which is our fourth one, concealing information from your attorney. This is a very important topic. It could be a very costly mistake, which could be the difference of you maximizing time with your kids, to having supervised visitation with your kids, to paying any type of alimony, to not paying alimony, to getting a better division of property and a lesser share of the debt, to a greater share of the debt and a lesser share of the property. And it's really going to boil down to, most cases, the judges making his or her decision based upon the veracity of the witness and how you're coming across. And so you really want your attorney to know everything. Some of these things I know can be very embarrassing. I've been doing this for over 15 years, and I think I've heard or seen it all. And as attorneys, nothing's going to shock us because we want to make sure that we're protecting you. So the more information we know, the better. And I mentioned earlier that we like themes. Courts like themes to help present your case. And we like themes in these webinars and seminars because it's something that you can take with you that will jog your memory, or at least you'll hold on to, as far as, should I do this? Should I not do this? Or, oh, that's what they said because I remember this issue or this comment or point based upon a theme. And one of the themes is the doctor versus lawyer. Again, I can't take credit for this, but one of my partners, Scott Trout, came up with this, and it's an excellent theme. And it makes a lot of sense, especially for this mistake, which is why we included it in here. And he says, he was talking with some of his friends that are doctors, and they say that their patients tell them everything, sometimes even too much information. And Scott said, well, that's interesting because sometimes clients aren't that forthright or honest with their attorneys. And the reason why this is an important theme is because when you go to your doctor, Scott always says left leg, right leg theory, meaning if you have an issue with your left leg, you're going to call your doctor and say, here's what's going on with my left leg. When can I see you because I want to try to get this healed? So you go into the doctor and you're not going to go and say, it was really my right leg. No, you're not going to say that because you want to be healed. Same thing with attorneys. You want to come in and you want to tell us everything. You don't want to sugarcoat it. You don't want to hide the ball. Just let us know what the situation is so we can try to heal you, essentially, which is to protect you, to advance your interest, to put our best foot forward so we can get to the heart of your case and really try to get to what your goals are and try to get you to achieve those particular goals. Another theme, again, I can't take credit for this, but I like it a lot, and so I'm going to use it, is the one-chip theory. And I didn't know, for those of you who are tuning in, if you remember, I think it was Lay's or Doritos, I'm not sure. But anyway, the point is you can't just have one potato chip, right? Just like last night, if anybody was watching the Super Bowl with all the appetizers involved. You just don't go and have one and that's it. I'm sure you're going through again and again, like me, filling more up on the appetizers than anything else. Well, same thing with lies, right? You tell one lie, it could lead to another lie and another and another. And all of a sudden you just got this big mountain of lies that it really is going to hurt your case. I can tell you this just from personal experience, that nothing is worse than when you're in court or in chambers and the other side brings up something that I was unaware of. Or the other side says, Judge, it's A, B, and C, and the entire time you've been telling me that it's X, Y, and Z. And that's how we've been presenting your case. That doesn't look good for me, but more importantly, and most importantly, it doesn't bode well for you or your case. Because I can tell you, judges they're human, and they're making decisions based upon what the attorneys are telling them or how you're coming across as a witness. And if you come across as a liar, the judge isn't going to believe anything else that you're saying. I've used it in cross-examination myself. My colleagues have used it when we catch somebody in lie. That's the theme. That's the picture that we're painting. We want the judge to know, what? This person isn't truthful here. They're not truthful in anything else. Especially when it comes to money or to kids, that's how we're going to start painting that picture. So as you can see, even one lie, even one little white lie, what they told you back in school, that one little white lie is okay, it's not okay in this type of law. We want to be truthful because at the end of the day, the court, the judge is going to base his or her decision, as I mentioned earlier, on your veracity and how you present yourself as a witness. And we'll go into some of this a little bit more detail throughout the presentation here. But again, that book I mentioned earlier, 10 Stupidest Mistakes Men Make, available on Amazon, it goes into much more detail. So I highly encourage you to check that out. So we're going to move on. I just want to make sure that we get all these mistakes in. So we're going to go into the next mistake here, which is mistake number 5, neglecting the children. We put this term on here, neglecting, because it has significant ramifications, right? It's a very serious, demeaning, hurtful word. It even looks awful to see as I'm looking at it on the screen. Neglect. Wow. Just let that sink in for a minute. Neglect. I know you're not neglecting your children, but we need to present your case in a way that the court knows that you're not neglecting your children. and you want to be an involved dad. And that really goes back to what we were talking about earlier as far as, do you want to move out? When is the best time to move out? When is the best time to file? As you can see, even though these are common mistakes we make, they all go together and one builds upon another. And we want to make sure that your goal is to maximize time with your kids. And in order to do that, we cannot have the court for a second think that you are neglecting your kids. Know everything about your kids if you don't already. It may sound minute, it may sound silly, it may sound meticulous, but I want you to know not just their height, their hair color, their eye color, their name, their birthday, their social security number, but know what level in school they are. Know who their teacher is. Know who their friends are. Know who their friends' parents are. Know their educational schedule. Know their extracurricular schedule. Go to their games. Know their friends' parents. Have play dates when you're with your kids. It's a lot of work that you're going to need to do now, but I can promise you that it's going to make our job much easier for you. It will cut back on costs, potentially time when we're preparing for your case. If we can have documents showing the amount of time that you're with your kids. I can tell you again from personal experience in cross-examination or even in direct examination of my own client, when I'm asking those questions, do you know your child's best friend? Do you know their favorite color? And especially on cross, if they don't know it, that makes us look good, because then that person's not as involved. Or on direct examination, that you are involved, that you know your kids, that you take the time to spend the time with them. And it's not just going over homework, but having fun time with them too. Take them out to the movies, take them out to the park, just spend time with them. But you're going to have to document that. And it may be an ongoing issue or thing you're going to have to do even after the divorce, in case something happens down the road. You have a document that you can refer to. And it doesn't have to be anything fancy or expensive. It can be a notepad, a notebook. If you have a phone, you can just keep it on the notes on your phone, depending upon if you have a Android or Apple. But there's ways that you can keep track of everything. So neglecting the children is a mistake that we really want to try to avoid. And people think, well, neglecting is if I just leave and I don't have any contact with them. It could be, but it's really focusing on who are your children? What is your involvement with them? We were talking about education, and we were talking about the fun activities. Make sure that you go to the doctor visits with them, to the dentist visits with them. I can tell you, when we subpoena documents through a process called discovery, in the notes, the majority of doctors write who is present. Mom presents with child. Dad not here. That, right in and of itself, show that to a judge. Mom presents with child. Dad not here. You could have been out of town on a business trip. You could have been in a meeting or just had anything to where you really could not be there, or mom may not even told you about this. So we need to stay ahead of that. And if you can go to these appointments and these visits, go. But also, if you can't, let's document that, or let's try to schedule visits on the time that you can go. Or you may not, as I mentioned earlier, you may not even be aware of this. So we want to point that out to the court, that dad didn't know that this was even going on. And we could try to turn it around, that you are an involved dad, that you want to be there for your kids, but mom's the one that is driving that wedge between you, that's really trying to cut you out of their picture. And that's not in the best interest of the children, and that's not putting our best foot forward. So that's what we mean when we say neglecting the children, is focusing more on how much time do you have with your kids and what do you do with your kids, and really knowing who your kids are. So I'm going to move on to our next mistake here, which is mistake number 6, doing a sloppy job on financial records. I think all of my colleagues use this example, and it's really the best example: tax returns. I'm fairly confident that you are meticulous on your tax returns. In seminars, we ask everybody to raise their hand if they take time on their taxes. And I don't think there's one hand that's not up, right? It's something that we are very diligent about, meticulous about, and we all fear the IRS. Nobody wants to be audited. So you spend so much time on your tax returns. Well, why wouldn't you do the same thing with your attorney? Depending upon the jurisdiction that you're in, there's financial affidavits. Here in Missouri, there's income and expense statements. These are one of the most important documents in a case. I can't tell you how many times they make or break a case. And the sloppiness just isn't forgetting expenses. It's simple addition, right? You see on the screen, we have pad, we have a pen, and we have a calculator. We're going back old school. And I want you to go back old school and write every expense down. We'll let you know if that's something that is reasonable or the court would take into consideration based upon our experience as attorneys, based upon our experience in that jurisdiction, and based upon our experience with that particular judge that you're in front of. But we want to make sure that we're capturing all of your expenses, especially if you're not in the same house together. So if there's dual expenses, we want to write that down. Why would you submit an income and expense statement or a financial affidavit that just lists the marital expenses? That doesn't make any sense. That does not give you an advantage. That gives you a disadvantage. And that's not putting your best foot forward, because now you're presenting to the court a document that you verified, that you signed under oath, that yes, these are all my expenses and I'm okay with this document. When in reality, you have all these other expenses. So when the court is looking at, is there any type of alimony exposure, they're going to say, oh, well, looks like dad has a lot of money left over, when really that money left over, if there really is money left over, you're using for your other expenses. A lot of our clients live paycheck to paycheck, and we need to point that out to the court that this isn't fair. This isn't equitable. There may be these expenses that are on here, but there's a lot of other ones. There's the ones that you have in your second location, which would be rent, which could be mortgage, which is all your utilities, which is things that are very important to help mitigate that financial exposure. So we want to make sure that that document we're presenting is accurate, and we want to make sure that all your expenses are on there so you can testify, which would mitigate or eliminate your financial exposure. We're going to move on to our next mistake here. We've got a little bit of time, but I want to make sure that we get through all of these mistakes. So mistake number 7, talking too much, especially to your wife. Is it a good thing or a bad thing that you have conversations with your wife? It's going to depend upon what those conversations are. I'm of the opinion if it's going to advance your case, then it's good to have discussions. But I also caution you really want to be more of a sponge and just listen, get an idea of what your wife is saying, what is she wanting, because then you can relay that information to your attorney and we can determine, yeah, that's a great deal. Let's put pen to paper. Let's go right now. Or what is she thinking? There's no way a court's going to order that. That is so unreasonable, so unrealistic. Let's start preparing for trial. The concern I have when there are substantive discussions with your wife, meaning you're talking about your case, is that you could be negotiating against yourself. And I can tell you this, if you are talking finances with your spouse, that's the only number that's going to resonate with them. It is going to be very, very, very hard to get them off that number. You make our job a lot harder. You're incurring more costs. You're incurring more time. You do not want to agree to anything because I don't know if that's a good deal for you. There's a lot of significant exposure you could have or ramifications that you're not even thinking about that you're going to talk to your attorney, not just the short of it, hey, I'm going to get more money in my paycheck. Let's look at long term. How does this affect on taxes? How does this set up precedents? What about a budget once you're divorced, right? You're moving forward. You had dual income. Now you're just relying on your own. Let's take those things into consideration. We also don't want to discuss evidence. We don't want your spouse to know our position. My partner, again, themes, right? Poker. I don't know how many of you out there play poker. He calls it Texas Hold'em. I don't really play that game too much, but again, poker, we never show our cards, right? In Texas Hold'em, you're dealt a couple cards, and you hold them close to your vest, right? So in trial or in evidence with your attorney, you're going to hold all this information close to your vest, and you're not going to want to disclose that. As Scott always says, if you've dealt dual aces, you're not going to lay them down, right? Because everybody's going to fold, and the only thing you're going to win is whatever the ante was in the pot. You want to get that pot up so you can win, right? Your poker face. Well, here, you don't want to let your spouse know who we have as experts or witnesses or what documents we're going to be presenting, because you're giving them a significant advantage. So you don't want to show your cards. That also helps in settlement too. If your wife knows everything you're going to be presenting, it's going to be very hard to try to resolve your case favorably to you. So no matter how hard the situation becomes or how much your wife is digging into you, because I'm sure that she knows what buttons to push to really get you going, do not disclose. Just walk away. There is no harm in walking away. I'd rather you walk away and have her be irked and upset that you're ignoring her than you either get into a situation where you're yelling and she's calling the police and now you're in a completely different ballgame, or that she's just mad at you because you walked away. We can use that to our advantage. We do not want to disclose our evidence because it could have substantial ramifications that are adverse to your case. I'm going to move on then to our next mistake, which is mistake number 8, revealing too much information on the internet. As we get into the years and we get more things that are available to us on the internet, it becomes damaging. What we put out there is always going to be out there. Trying to permanently delete something is impossible, and you don't want to be in a position where you could be accused of spoiling evidence. That could have serious ramifications. For example, in Facebook, you don't want to delete your account. You just want to deactivate. You want to be very careful what you're posting on Facebook, on all social media, such as Instagram, Twitter. There's so many other things out there. I'd have to talk with my 5-year-old cousin to figure out what all is out there. But the point is, you want to make sure that you're not posting anything is ideal. But if so, be positive. I can tell you that if you're saying bad things about your spouse, that's not going to fly with the court. If you're posting pictures of yourself out partying with your friends, that's not going to fly with the court. You could not have time with your kids, right? It could be mom's weekend, but here you are, you're out and about, and you post a cool pic that you think your friends would like to see, and lo and behold, it's you just holding a beer. You may not have even been drinking it, but now you're painted as an alcoholic who'd rather go out and drink with their buddies than spend time with their kids. Or you could be tagged in a post. So you don't want to be tagged in something that could have harmful effects to your case that you don't even know about. So if you're going through a divorce, I would say just deactivate all your social media accounts until afterwards. And if you just can't, you have to have that involvement in social media, don't post, and have conversations with your friends not to tag you or post pictures with you, because we want to make sure that we're putting your best foot forward. And once it's out there, it's out there. And it could make our job a lot harder and take time and money that we could use in other potential areas and avenues in your case. So social media, it's a double-edged sword. It's great for information, but also that information is great for the other side too. So be very, very careful on what we're putting out there. We're going to move on to mistake number 9, failing to fully engage in your case. This really boils down to just involvement. And we've talked about as far as what questions to ask your attorney and documents to be keeping and tracking, but also ask your attorney, what are the cases, what are the statutes we're going to use, so you can just read them. You're not an attorney, so you're not going to testify to them, and you're not going to even be asked about them, but get an idea of what is the court going to base their decisions on, so you know, and then you know how to act in the best interest of your case. And questions to ask your attorney, and just generate some really good discussion with your attorney. Know the exhibits. The number one thing we mentioned earlier is that the court's going to judge you by your veracity and by your competency as a witness. And if you're up there and you're prepared, that's going to go a long way, because you're going to come across as authentic. You're going to come across as knowledgeable. You're going to come across as concerned. And attorneys will prepare you for that, but if you know those exhibits inside and out, that's just going to come across much better for you. One of the things that we do here at Cordell Cordell is all of our attorneys are constantly in communication with their clients. As a client, you will never ask what is going on in my case. We have a client portal. You can log on in anytime you want. No extra cost. It's on your time. You can log on from any device and know exactly what's going on. You have access to your file, the notes, documents, important information. So you are always kept current. All of our attorneys are going to send you a litigation roadmap. Here's where we're at. Here's what's going on. Here's my concern. Here's how we're going to approach the situation. Here's a case law, the statutes that we're going to be relying on. And as cases progress, things change, goals change, issues arise. So we want to make sure that we're all aligned on the same page when we're putting our case together and putting our best foot forward, that you're involved and you know that information and you can come across as a good witness. We also want to make sure that when you're talking with your attorney, track your bank statements, track your credit card statements, bring in your W-2, bring in your tax return, read these documents. These are very important. Something may stand out in those bank statements or credit card statements that could be a red flag that could help us out. So we want to make sure that if we see that, not only are we aware of it, but we're taking proactive action and subpoenaing documents that could make or break your case. So again, failing to fully engage in your case isn't just hiring an attorney and letting them do everything, right? It starts there, absolutely, but it's the constant involvement, making sure that your questions are answered, making sure you have questions, making sure you know where are we at, what are we doing, what is the game plan, right? If you follow any sport, no one's going to go into a game unprepared. Those coaches know the other side. They've done their research. We need you to do your research. Those statements, the financial, the debt. Another big issue is going to deal with property, right? Walk through your house. Take video. Take photos. You may not want that piece of property, but there's value associated with it. And it goes back to, when do I file? When do I move out? There could be something of value that we need to get out of the house. It's a lot easier to give something back than to try to get something back. So we want to make sure that there's no dissipation of assets. Again, putting your best foot forward, preparedness. So takeaway on failing to fully engage is being prepared. Knowledge is power, right? We don't want to fumble. If you fumble, you may not be able to recover as you can in football. One fumble could cost you the entire game. That fumble in this case could be the difference of you seeing your kids, not seeing your kids, restricted time versus supervised time, or little time at all, paying alimony, not paying alimony, getting a better property deal versus a not so good property deal, or unequitable division of the assets and debt. So be prepared. Move on to our final mistake here, which we have just enough time to go over. Being ill-prepared, leading right into it for testimony and interviews. What this means is it's a good segue from the last mistake, right? Knowledge, fully engaged. Well, here, going back to being prepared, you want to know what you're testifying to. I can't tell you how many times I've had cases where we were prepared and we show up and there's the other side meeting with their client for the very first time. To me, that's just malpractice. You won't get that at Cordell Cordell. We have policies in place to where if you have a hearing, you're coming in 2 to 3 days before that hearing to go over what's it going to look like. What's your testimony? If there's exhibits, what are they? How are you going to testify to? What do they mean? And if it's a trial, you're coming in at least a week in advance to go over the trial. And it's going to depend upon what the issues are and where we're at, meaning the county, the judge, and how long the trial is set for. But you're going to spend a lot of time yourself being prepared, and then you're going to spend some time with your attorney and the paralegal knowing what are the documents, what are the evidence. Because when you testify, remember, knowledge is power. You want to be able to give the correct answer to the court, that you know exactly what this document is, why it's important, and how it's going to advance your case. Remember, the judge is looking at you and your spouse to determine substantial issues in your case. And if you're coming across unprepared, that could mean, I don't care. And that's not the truth. So we want to make sure that you're prepared. If there's any testimony, you're going to meet with your attorney and go over, especially at Cordell, we're going to go over, here are the questions we're going to ask you. Be prepared. Let's go over it. Let's see how you come across as a witness. We want you to be authentic. Then what we're going to do is we're going to put on the other hat, and we're going to think, oh, so if we're the other side, here's kind of the questions that we would think that they would ask you. So you're prepared. So you're not caught off guard. So you're not stumbling. So you're not fumbling, right? We want to make sure that you know how to answer, what to answer. I can't tell how many times on cross-examination where one simple question breaks the case. It's, for example, well, what time is it? Well, it's 11:59 or 12:59 on Monday, February 4th. Why? That wasn't the question. Just what is the time? 12:59. So the more information you give, you're really helping out that other side. So you really want to be prepared, engaged in your case. Everything is on the line. So keep that in mind when you're meeting with your attorney. You're deciding who to hire. You're deciding when to fire. You're deciding if you should move out, because you want to make sure that you're putting yourself in the best possible position. And you want to make sure that you're advancing your case and you're putting your best foot forward. Unfortunately, it looks like we've ran out of time to take any questions or answer any questions, but I would encourage you, if you do not have an attorney, or if you're looking to set up an initial consult, we do have an office in our Louisville office, and you can find that number on our webpage, CordellCordell.com. Also, check out some of our other resources, such as mensdivorce.com and dadsdivorce.com. Thank you.